Copwatch, policing the police every single day.
Charlotte County Sheriff Bill Prummell is guilty of this theft and fraud and conspiracy to keeping records away from Copwatch, who exposes his corruption. The same things are happening to me. Illegally charging for searching, charging me for documents, then giving me nothing. This is literally becoming a RICO issue where government agencies are starting to work together to prevent people from exposing their corruption. Files public, but at a cost. Do Sarasota County Schools fees for emails flout state sunshine law? By Elizabeth Ginnies. Elizabeth.Ginnies@heraldtribune.com. In July 2016, Sarasota paralegal Michael Barfield made what seemed to be a standard public records request of the Sarasota County School District. Barfield asked the district for all emails containing the word Zucker over a 4-month period, presumably referring to the last name of school board member Caroline Zucker. 3 days later, the district responded, Barfield could have the records, but his request would cost him about $1,000 based on the staff time required to find them and redact, or black out, sensitive information. Barfield then amended his request, asking only for emails that mention Zucker in the body of C. Public, A5. Public. From page A1. The message, rather than in the to or CC line. He was given a revised charge of more than $700, he said. After a stretch of summer vacation, Barfield sent the school district a check for the full amount in October 2016, which the district acknowledged it received. But after almost 4 months, Barfield still had not received the emails. This back and forth was far from unusual for Barfield, who is known for his long-running and often controversial campaign to force local governments to comply with the state's public records laws. But the delay was ridiculous, Barfield said. So, with no response, he sued the district in early February 2017 for refusing to perform its statutory duty to make public records in its possession available for inspection and copying, according to legal documents. Within 3 hours of filing the lawsuit, Barfield got a speedy response from the district's attorney, Art Hardy, with some of the messages he had requested. Soon after, Barfield was refunded his attorney's fees and settled the lawsuit at the district's expense. To me, it was really weird, because it meant that they had had these emails all along, Barfield said of Hardy's same-day answer. It's not often that I get records within hours of filing a lawsuit. And there were very few redactions in those emails. Barfield's legal and financial resources, which helped him get the records he sought, exceed the average person's ability to force a government body to follow the state's public records laws. The paralegal can be a polarizing figure in local government circles, but his issues obtaining public records from the district are not unique. They highlight problems that have come to light in recent months with the district's maintenance and accessibility of public records. Over the past year, the district has repeatedly charged high costs for simple records requests and delayed fulfilling them for weeks or months. The common explanation, a need to withhold information in the interest of student privacy. After being presented with many of the examples referenced in this article, the district's spokeswoman said that, while improvements could always be made to the system, the district has been complying with public records law. I do believe that the district is doing all that it possibly can to make sure that we are in compliance with the law as we understand it and know it, said Tracy Beaker. I don't believe that there is any case where we are purposefully not fulfilling a certain request or being responsive. We also have to be responsible and make sure that what we're doing is accurate and right, and, in some cases, that takes time to make sure that we're able to do that. Public records. Much of how one construes Florida's public records laws falls on the interpretation of the word reasonable. State law specifies that anyone who has custody of a public record must allow for the inspection and copying of that record at any reasonable time and under reasonable conditions, according to Statute 119.07. Charging for the production of public records is allowed under the law, as long as the task requires extensive use of information technology resources or extensive clerical or supervisory assistance by personnel of the agency involved. But the special service charge must be reasonable and based on the cost taken on by the public records agency in question for the production of those records, according to statute. The question is whether $1,000 would be considered reasonable, or even $3,000. Both are amounts the school district has quoted journalists for complying with records requests. In the past year, the district has frequently quoted high-cost estimates for producing public records that would appear to be routine requests based on how other agencies handle them. After a Herald Tribune investigation revealed that the president of a public relations firm retained by the school district had been posting comments under fake names on the newspaper's site, the Herald Tribune requested all emails between Sarasota County school employees and the PR firm's employees in the more than 7 months before the firm was hired to the end of its employment with the district. The district offered an estimate of more than $3,000 for producing the almost 9,000 emails. Then Communications Manager Scott Ferguson, who has since retired, said that it would take the Information Technology Department 5 hours to simply pull and prepare the requested emails from their internal system and the Communications Department more than 130 hours to retrieve and prepare the public records. In another instance, the Herald Tribune requested all community responses over the course of 2 days sent to a district solicitation for public feedback on Sarasota County school security following the school shooting in Parkland that killed 17 students and teachers. When the newspaper requested more than 400 emails that community members sent to the email address, which was presumably intended to be made public, the district replied with an estimate of more than $400, based on the retrieval and preparation of emails that had been sent only 3 days earlier. In late March, the teachers' union made a request of the district for all communications over a roughly year-long period between Superintendent Todd Bowden, the district's head of high schools, its chief academic officer and the head of pupil support services. Fulfilling that request would take more than 200 hours, the district said, and cost the union more than $7,000. But perhaps the district's costliest estimate came in 2010, when Kathy James, then running against Jane Goodwin for school board, made a multi-layered request including emails and budgetary documents. The district responded 2 days later, saying it would take 2,500 hours at $24.75 an hour, coming to a grand total of almost $62,000. James decided to abandon the request. James said that high cost raised red flags for her. If everything is above board or if they're doing all the right things that they say they are, why is it so laborious and cost prohibitive to share it? James said. District officials argue that the costs are outliers for large projects that take extensive staff time. The average request to the district's cost are $30 to $35, said Beaker. If it's under an hour's worth of time, we're not going to charge you for that, Beaker said. If it's something we have easy access to, we're not going to charge you for that. In the case of the high cost for emails intended for the public, Beaker said that the security responses contained numerous statements about specific children that would be exempt from public record. Some parents put the names of their children in things like that and where they go to school, Beaker said. We had to go back and search each and every one of those in order to be able to determine whether there was something in it to be redacted. Still, other academic institutions have handled requests differently than the district. In May, James made essentially the same records request of the State College of Florida, Manatee Sarasota, and the school district. SCF replied to her request in 5 days with an estimate of less than $10, the cost of the USB drive and postage, whereas the district took 12 days and said the documents would cost her almost $100. The district frequently argues that extensive public records requests require extensive time to examine. But in the case of 10,000 emails between 2 school board members or 10,000 emails between a principal and a teacher, the latter being far more likely to contain information about specific students, they are treated the same. The process is very much the same, regardless of whether we feel confident that something has the potential need to be redacted or not, Beaker said. We have to sift through all of that with human manpower. When cost has not been an issue, delayed responses have become a problem. In early January, the Herald Tribune made a records request asking for the number of convicted felons attending each district school and their names. The district initially said it couldn't respond because the official who could produce the information was absent due to illness. It took nearly 3 weeks and more than one follow-up email before the district offered another response. It could not answer the question. Instead, the district directed the Herald Tribune to the Florida Department of Juvenile Justice. At other points, the district has indicated that it does not have a proper archival system for documents considered public record. In January, the Herald Tribune requested written correspondence, defined as letters, to school board members during the month of January. Most correspondence is electronic and beyond email, is published on the district website, including agendas and minutes from the meetings, Beaker said in an email that day. Sometimes, we get letters from community members. Depending on the nature of the letter, they are either filed, shared with colleagues or discarded once action is taken, she wrote in the email. Since that response, Beaker said the district has amended the policy. They now retain and file every piece of written correspondence to board members. Having discarded the written correspondence would appear to be a violation of public records law, which requires that public records be retained. Beaker disagreed with that interpretation, noting that the process of retaining letters was particularly difficult because they would often get sent to board members' houses rather than the district's offices. I don't know that it was a violation of the law, and it was certainly not something that was done intentionally, Beaker said. I think it was simply a matter of not knowing and not having a system in place of being able to keep those types of records. It's just really getting clarity and clarification in terms of what is personal versus what is school-related. Determining cost. Emails from any Sarasota County Schools employee typically come with a tiny cautionary note in gray print at the bottom of the message. Please be aware that all email to and from Sarasota County Schools is subject to the public records laws of Florida. Yet the school district relies on a retrieval system that makes it difficult to actually obtain these records. District administrators refer to their own internal formula for determining what they charge for a public records request. A public records request for email requires IT staff to enter the search parameters into our archiving application, Information Technology Director Joe Binswanger explained in an email. Depending on the parameters of the request, the amount of time to pull the emails from the archiving application varies. This process could take anywhere from 15 minutes to 5 hours, based on various time estimates provided by the district for different requests. Next, the district passes the request along to the communications department, which reviews each email individually to ensure that the proper information is redacted, he says. The communications department has a spreadsheet that has been developed over the years that allows them to make an extremely accurate estimate based on the number of emails produced in the request correlated to the amount of time it will take to go through the found emails to prepare them for the request, Binswanger wrote. As an example, preparing emails requires staff to review every email to ensure no student data is included. If there is student data, then it must be redacted prior to the release of the record. Student education records, as well as correspondence that discusses them, are protected under the Federal Family Educational Rights and Privacy Act, which is referenced in Florida Statute 1002.22. Binswanger added that the cost is attributed to the cheapest hourly rate of the employee who can perform that request. Yet based on 3 different public records requests made over the course of this year by Herald Tribune employees, the cost per email has varied significantly. Cost per email ranged from about 35 cents, for the request related to the district's private public relations firm that briefly handled district communications, to nearly 90 cents in regard to the more than 400 school security feedback messages. Ferguson, the district's former communications manager, said high costs occur when a citizen makes a very broad request that requires extra sorting. I think a lot of times when what seems like a lot of money is asked for, it's because there are hundreds of thousands of emails, because they are asking for pretty wide parameters, Ferguson said. They say, we want communications between all of the board members for a certain time frame, and they don't realize that there is a human going through all of those. Cost per email is not the right measurement to use, Beaker said, because the formula is based on time rather than emails. But Binswanger's description of the formula indicates that the ultimate cost is based on time as it relates to number of emails, meaning that the number of emails would always have an impact on the cost. In any case, cost per hour varied as well, although less significantly than the email cost. Out of the 3 requests, costs ranged from about $21 per hour, from a request by Herald Tribune reporter Kim Dolato of 99 emails sent to the district's town hall email in March, to about $25 per hour, for the school security responses. Local governments. But a check with other public officials suggests that the school district's approach may be unnecessarily labor-intensive. Both the city of Sarasota and Sarasota County have had websites where at least some of the government's emails are made publicly available. On both sites, a user could view officials' most recently sent emails or enter search criteria based on the text within the email and the dates when they were sent. The school district does not have a similar database to collect and view any emails exchanged among district employees or school board members. Ferguson could not recall whether an email database system had existed in his 10 years with the district, although James said she remembers having widespread public access to school board members' emails that ended in 2010. Sarasota County began its system in 2007, with the rule that any email from one county commissioner to another or from a commissioner to the county administrator would show up on their public database, said Glenn Zimmerman, the county's chief information officer. It's a pretty simple process to maintain, Zimmerman said in an interview. But for those emails that do not fall under the parameters of public communications, the county said it generally charges those requesting documents only for the cost of the CD or flash drive used to distribute the requested documents. Even in the case of a request yielding 5,000 emails, a hypothetical posed to the county's public records coordinator, Kim Francel, she said it would not require more than a reasonable amount of time, defined by the county as 30 minutes, to complete that. I don't see 5,000 emails to be taking more than a half hour, Francel said. From my experience, I think we would be able to do something like that. See Public, A6. Paralegal Michael Barfield is well known for pressing governmental agencies on public records laws. Barfield says the digital records system the school district uses is outdated and non-compliant with state law. Herald Tribune Archive /2015 Mike Lang. Public. From page A5. Francel said she didn't think the county would ever charge over $1,000 for a request. In her experience, one of the county's largest requests yielding thousands of emails over a very long period of time cost the requester about $400, Francel said. We've never really even gotten close to $1,000, she said. Francel had seen only a handful of emails in the past 2 years that required redaction. While the city of Sarasota has attracted controversy in recent months for its public records system, it formerly had an online database and kiosk available at City Hall where members of the public could look at the emails between city commissioners, the city manager, city auditor, and city attorney, according to city auditor and clerk Pamela Nottolini. That changed in February 2017 and has not been restored since then, to the consternation of some residents. For those records requests that were never included in the city's public access, Nottolini said city officials have tried to keep the cost down. She said the city can charge for records retrieval, but does so through a lengthy process. It really has to be something that they can justify, that it really has to be extensive research, Nottolini said. Technological solution. Barbara Peterson, president of the First Amendment Foundation, has a phrase she likes to use when she thinks of public records in the digital age: for every technological problem that exists for public records, there is a technological solution. The simple reality, she says, is that most agencies aren't using these technologies to make public records more accessible. Florida law stipulates that as each agency increases its use of and dependence on electronic record keeping, each agency must provide reasonable public access to records electronically maintained, according to Statute 119.01. Ferguson, the former district communications official, said it makes sense that the district does not make its emails readily available to the public, considering there could be student information in many emails that cannot be disclosed to the public. To create an online public database of emails between school board members and the superintendent would require a human going through each email and screening them, Ferguson said. Still, many agencies view it as one of their obligations to keep exempt information out of emails that they know to be public record. In the case of Sarasota County, Francel said that her employees were keenly aware of that. We try hard not to transmit those records via email, because a lot of that information isn't public record and must be redacted, Francel said. We have good staff that are very aware of our public records laws and they do a very good job of not putting out there something that would need be redacted. As someone with extensive historical knowledge of the district's handling of public records requests, James said that she has often heard redaction as the reason for high costs and delays, but then received her documents only to find little information actually redacted. Historically, that's their excuse for why it takes so long and it's so high-priced, James said. That is a loophole for them to excuse themselves for their prices, in my opinion. Some agencies across the state ask their employees to flag emails that they know contain redacted information or mark the confidential nature of the email in the subject line. Not having any kind of exempt information system could be interpreted as making it harder for the public to access public records, Peterson said. We the people who have the right of access are suffering from their poor management skills, in the sense that they're not managing their correspondence and the ease by which they just shoot off emails, Peterson said. They're not considering the fact that those emails are public records and that we have a right of access to those records and they're not supposed to be creating barriers. But the nature of working in a school district creates certain situations where an email is the quickest way to communicate certain information, said Beaker, the school district's spokesperson. When you are trying to do something relatively quickly dispersed throughout the county, say an executive director at a school is corresponding with someone about a situation and a person's name may show up as part of that situation, there are cases like that where more than likely some pertinent information would have to be redacted, Beaker said. But we put that in an email because it's the fastest way to be able to correspond when not all of us are sitting at the table together. But that reasoning ignores a simple technique that could alleviate the district's labor-intensive redaction efforts, redaction software. State law specifies that an agency may not enter into a contract for the creation or maintenance of a public records database if that contract impairs the ability of the public to inspect or copy the public records of the agency. When asked whether the district had redaction software, Binswanger said no. Barfield said the district's digital records system was one of the causes for any difficulty in accessing their public records. I'm not saying the district intentionally overcharges citizens for records requests or delays, said Barfield, but the system that they use is outdated and not in compliance with Florida law. Still, for many Florida agencies, lining the path to public records with obstacles remains intentional, Peterson said. Agencies know that the chances of you suing them are slim to none, Peterson said. So they get away with it?
Copwatch, policing the police every single day.
Hello? Yeah, can I talk to somebody about, I'd like to file a complaint of theft.
Yeah, I can call a deputy in.
All right.
It could be a while. I need you to fill this out. Is that a camera?
Huh? Yes. We're in a public place.
Yeah.
Just some people freak out and run away.
Okay. And I need you to fill this out.
Mr. Sheets?
Yep.
I'm Sergeant Brandon, sir. How can I help you?
File a complaint of theft. Do it here and there?
No, here's good.
Okay, that's good. All right, so anyways, it's with the Records Department, and the name we got on here is Melissa Jones. This went on over weeks, in fact, almost a month, that I asked for sunshine law requests for bulletins, bolos, and or photographs of Xander sheets. Because everybody they know that does Copwatch, they've all got them. It's kind of a trophy, right? So I've been asking, I've been trying to get them. Under sunshine law, if you ask for a detailed list, they're supposed to give it to you. She would not give me a detailed list.
Okay.
So finally I gave up. I paid the money. That's what all the documents are. I gave up, I paid the money. So that's what she charged me. Okay. You know, the way that it's written, you know, it's that there's something there, right? 198 different things. I'm going to pay the money. Something's there, right?
Okay.
All right. So this is what I get back. Okay, we used your money to look through the documents and we found nothing. In fact, we went overtime and we're going to let you off on that overtime looking through the documents. Barbara Peterson from the First Amendment Foundation is already aware of this, so she knows about it. So this is, after this is going to go to, you know, mediation, court. That's why I'm here to file, because my money was stolen. After that, I'd like to speak with IA, because this is just an ongoing thing that's just getting worse and worse.
Okay, so how was your money stolen?
I paid for something and received nothing.
Okay.
Okay? Received nothing. That's what this one, you know, I'd like these back, but you can take copies.
So you're disputing the information that you were...
Correct, correct. So, and this is all in your emails. That's why I like emails, because everything is documented.
Okay.
All right, so anyway, so here's where she informs me, okay, we went through the documents, we don't have it. In fact, we did an extra hour and a half. Another thing, you can't charge for searching, for looking like this. You cannot do that. If I would have got the detailed inventory list that she did in the first place, I would have known what she was doing, which was, I'm going to show you here in a minute, which was wrong. She didn't even do the proper search that I asked for, okay? All right, so anyway, so then I said, okay, fine, I already paid for the documents. Give me the documents, okay? I don't care if my picture and bulletin is not on there. Give me that. I already paid, okay? All right, so she said, well, that's a new request. Now we're going to have to charge you $150 to get those same documents she just went through that I just paid for. That supposedly a bulletin or, you know, picture wasn't in there, right? Okay, then I said, okay, just give me the papers where my name is on it. Okay, that's it. So then I get another bill for $150. Like I said, First Amendment, Barbara Peterson is already aware of this. She's got the documentation. She knows that this is really wrong. So finally, so Barbara Peterson said, put her in the carbon copy, and to get the detailed list of what all this has been about. Okay? So when I finally did that, magic, I finally get a detailed list. So as you heard, I asked for bulletins, bolos, and pictures, right? I just realized that when I printed it, but you guys already got it in your database, all she did is she did a search for my name. Not for bulletins, not for bolos, not for pictures, my name. And then also, like I said, if I would have had this in the beginning, I wouldn't be here filing a charge, okay? 80% of the stuff that came up are records requests that I made. Of course, my bolo, picture, and bulletin is not going to be in my own records requests, okay? You got it all in your stuff, you know, in your system. I got it. So this, my money was stolen, period. If I wouldn't, this is what I asked for a long time ago. It's in all the emails.
Okay.
If I would have got this, I would have called her BS right there, okay? She would not give this to me until the end, until I turned her into First Amendment Foundation. Then I finally got this, and now we all know that it was all BS. These are my records requests. Of course I'm not going to be in there. 198. In fact, she actually even called it 198 cases. So my wife's freaking out. Holy crap, I'm in 198 cases. And then we get this, we find out it's not even cases. It's my records request. That's not what I asked for.
Okay.
So like I said, I spent $45. I have nothing. First Amendment Foundation is already aware of it. But I'm here not only to file a complaint of theft, but I also want to file with IA because in fact, this is what's sad. She just did it again. Even after turning her into First Amendment Foundation, Barbara Peterson is aware of what's going on here with the Sunshine Law violations.
Right.
She just did it again on a records request where she wants to charge me $52 for something that I asked for. I said I need a detailed explanation because of what just happened here, and you're supposed to get that anyways. And again, she won't say it. She said it's in your bill. She said it's at the bottom, and all it says is 30 minutes to look at the document. You can't charge for looking. You have to do the search, as you just saw there. Do the search. Give me that if I ask for that for the detailed search, and then I can decide. Okay, it's good, bad, or you didn't even do the proper search.
Okay.
So I am out $45, and she has it, and this is ongoing. I mean, it's just gotten worse and worse and worse over the years.
Okay. All right. So because your complaint, I can make a copy of this for you.
And it's in your emails already.
Okay. Can you give me a copy of this, please? Hey. Thank you. So because of your complaint, what I'm going to have you do is fill out a complaint form.
Right.
In regards to the issue that you just explained to me?
Yes.
All right, and then you can turn this in and we'll deal with it like that, as opposed to a theft report. All right, does that make sense?
Why wouldn't it be called theft?
Well, because it sounds like what you have is a dispute about the services that you were provided. You pay for a service. And,
correct.
And you're disputing getting that service.
Okay, so you do this with everybody that has theft from a service? With this?
I have my badge.
You get what I mean? Like if somebody stole my money at a store, you do the same thing like with this paper?
No, that'd be a little bit different.
That's kind of my point. So anyways, all right, fine. I'll start out with this. That's fine. Okay, so
Excuse me.
so what, just fill in the little tiny room here?
Yeah, you can sit. I think there's a desk or a table
All right.
or something in there. You can.
Okay, and then, yes, and then I'm going to, well, actually, I'm not sure. I'm going to turn this in where, are you guys going to hang out, or I'm going to turn it into her?
Turn it in right here to the front
All right,
desk.
and then after that, when I'm ready for IA, then just tell her I'd like to talk to IA, or?
Yes, and in the meantime, I'll let them know that you want to see them.
Yeah. What happened to Clements? I heard he's not in the IA anymore. Is that true? Scott Clements.
I don't know.
All right, that's fair. All right, I will get this filled out, give it to her, and yes, let them know that like I said, this is just, over the years, it's gotten worse, 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 and First Amendment Foundation totally agrees.
Okay.
So,
All right.
no I will get it filled out.
Yes, sir. Thank you.
Already told me to fill that out and turn it in. And then also I let him know that I would like to talk to some of the internal investigations. He said he was going to tell somebody too. I'm just letting you know too.
Okay, so are you waiting for them, or are they supposed to be coming?
I'm just making sure you can let him know that, to remind him again that I do need to talk to internal
Okay.
investigations also. Yep.
So you got your information complete there?
Yes.
Okay. All right. Do you happen to have ID on you?
For,
Well, just verify who you are. I've never actually met you before, so. 14 of 65.
Are you serious? Nobody knows of me?
Oh, no. No, people know about you.
All right.
Okay, Mr. Chief, so I'm going to receive your complaint, so I want to be in touch with you in the near future, either myself
All right.
or another member of the office.
How about the IA guy? Is he available today?
No, I did call, and he's out of the office today.
All right. Is Clemens still there? I heard he's gone.
No, it is Zakowicz.
Okay, so he is gone. Did you hear why he's gone?
No.
All right. Is Carl Steele's smashed car here or no? Carl Steele, he smashed his car. Is it here or is it at the shop still?
I have no idea what you're talking about.
I'm texting with the victim right now. You have a good day, man.
Okay, you too.
Thank you.
Sir.
Hey Charlotte County, this is Charlotte County Copwatch, and I just wanted you to know that I am using this stuff under fair use. And also remember to like and subscribe this channel. Also too, keep in mind I do not make any money on YouTube. This is 5 hours work a day, you know, fighting for freedom. And you can donate with PayPal and Patreon. I just want you to think about this. If everybody gives to PayPal and Patreon is every month. Actually, PayPal you can do every month. I have 12,000 subscribers. If everybody gives, I can quit my regular job and go full-time investigations on Charlotte County and possibly even more and beyond. So just keep that in mind. If everybody helps out, I can go full-time doing this. Thanks.